340.6.
Okay, so this simply reads, further resolve, blah, 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 recommends that the statute of limitations for paraprofessionals for
Claims against paraprofessionals.
for claims against paraprofessionals should be the same language as below. So it's for claims against paraprofessionals. And you need to mirror the language below that says for wrongful acts or, yeah, the rest of that sentence.
Other than, yep.
Then, yeah, just to the end of the sentence. And then put a comma after services.
Then
Okay.
shall be governed.
Sure.
Okay, let me read it one more time. Recommends. Right, okay, so that makes sense. Is there a second for that motion?
I'll second it, Dana.
Okay, so we have a motion by Stephen, second by Dana at the top of the screen. Any further commentary about this before we take a vote? Amos?
Yeah, I just want to make it clear, and this probably is clear already, but I appreciate Brady giving the overview, and I do think this warrants a separate vote because of this discussion and a similar discussion at the regulation subcommittee. Just want to make it clear that this is not what the regulation subcommittee recommends. I don't think there was a difference of opinion. I think we unanimously are recommending the second resolved that's on the screen.
Including the 2 years?
Yeah, changing it to a longer period, 2 years instead of
Okay. Ira?
more public protection.
I just have a question. I wasn't thinking about the cost of malpractice insurance being affected by this, but of course it would. But I'd like to, a couple people, Steve and somebody else, maybe Brady commented about it. And I'd like to know how strongly you think the statute of limitations from 1 to 2 years would affect the price of malpractice insurance.
In my opinion, for a brand new program, it's huge. You have a very well-functioning market in California for legal malpractice insurance based on 340.6. If you're an insurance company and you're going to try to come into this market, you have that as background. That's going to make it much easier for you to underwrite the program and get involved. There's a big difference between 1 and 2 years.
This relates closely to your field of practice too, doesn't it, Steve?
Yes, I did this work for a while and I still represent a legal malpractice carrier.
Okay, so Carolyn, then Judge Rubin.
Okay. Yeah, I would, yeah, it'd be hundreds of dollars in a month, a month. So it could be thousands of dollars a year. And sometimes $500 a year is a struggle for people, just in the licensing fees. But I just wanted to really check, Amos, is it mandatory $100,000 bond, but optional and encouraged malpractice? Is that where we ended up?
Yes.
Yeah, that is.
Thanks.
That's correct. Judge Rubin?
Thank you. Can I ask just for maybe Mr. Fleischman, maybe the guy, I was wondering about the language in the first paragraph. We use the term statute of limitations, which is like a term of art. The statute itself speaks in terms of actions against. And one of the reasons I think it does is, I don't know if I'm getting this right, but it almost looks like there's a statute of repose clause in there, which says that you have 4 years from the time the event occurs, which typically is language, a different type of language. I'm wondering if we wouldn't just change it, recognize that the actions against the paraprofessionals be governed by, I don't know, 340.6. I'm on the appellate division of our court. I've just started to run into these statutes of repose, which.
Yeah.
And Mr. Fleischman, you're an appellate lawyer, guide me on that.
340.6 is in chapter 3 of part 2, the time of commencing actions other than recovery of real property. And my understanding is these are statutes of limitations, and that statutes of repose are elsewhere or in the common law.
But check in that.
And there isn't really much of a difference, but if you would prefer that the time to bring claims against paraprofessionals, I'm fine with that.
Yeah,
That's
we
fine.
could say that. We could just say, recommends that the time to bring claims.
Just because that one subclause, I just don't understand.
Yeah, no, I
So
hear
take-
you.
So, yeah, let Linda do this. Time to bring claims. Right,
That makes
Okay.
more sense, actually.
okay. All right,
Not
so
one,
I
that's
haven't seen any more
probably-
hands, so Linda, I think you can take a vote. And I can't hear you.
Sean? Sharon? Okay. Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes,
Hamilton, oh, sorry, he's not here, Hartston,
No,
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
No.
Robinson,
Yes.
Judge Rubin,
You're muted, David.
Said yes.
Shining,
Yes.
Sarouche. Maybe Fariba had to leave, Spiro,
Yes,
Torres Ambriz, I think they had to leave, Judge Wiley,
Yes.
Judge Yu,
Judge, you had to leave, remember?
yes,
Before.
the motion carries.
Right, thank you.
So for the last one, Linda,
And I will say that I think come 4:30, we're gonna lose more people and not have a quorum. So either we get through it, either it's something we can get through relatively quickly, and if we can't, we can't. So let's just start taking a look at it, but we're gonna have to conclude at 4:30.
so why don't we put up, Linda, if you could, the other sheet of resolutions, which cover these 7 areas where there was unanimity. On the assumption that everyone read the memo, perhaps we could have a motion to pass these recommendations and then address any questions or concerns.
Brady, can we pull the attorney-client privilege out and pass the rest? I have issues there.
Sure.
And if you go slow and scrolling on those, I'll go through them.
I'm just working to set it up so that people
Yeah.
can see it.
I'm sorry, Linda, I had to step away for a second, but my vote was no on the last one. I'm trying to hang on to this call as long as I can, but I have another meeting that I'm late to.
And I'm sorry about that, Sharon. I was just saying we're going to conclude at 4:30 because we are losing too many people. And whether it's a question of there being a quorum or not, I think it's also a matter of, as chair, just prefer that we not vote on things without having a real majority of the working group.
So what I heard from Stephen was basically a motion to pass these with the exception of the lawyer-client privilege resolution, which is on the bottom of page 1. So maybe take that one off, Linda.
Move it. We can come back to it later.
Right.
I move we adopt these 6 resolutions.
Do these all fit on one page, Linda?
Let me see.
Okay.
What's the exact title of the memo? I have so many memos. I think I downloaded and read them all, but The names are so confusing. Which one
It
is
was,
this?
Statutory and rule changes recommended for program implementation.
Okay.
I have the 3-ring binder.
Was there a second on that motion?
I second it. It's Kim.
Okay, and this is the one that talks about the IOLTA accounts. In the first one, the further resolution is the continuing education credit. Right. Yeah, I remember all these. All right, so we did remove that one that needed to be removed. And Stephen, I think your hand is up. Is that correct?
Just to make the motion.
Oh, okay.
Julia?
Isn't this just the same as attorney rules? Is there anything that's different?
So the only thing that is different here is that in the realm of MCLEs, while we decided to recommend granting paraprofessionals MCLE credit when they appear at an approved MCLE event as a panelist, as I'm sure many or most of us have done as attorneys. So we included that, but we did not include a recommendation for MCLE provisions for teaching at a law school because there's no indication that that's something that's going to happen. Paralegals currently aren't allowed to do that. So it's just seen as too much too soon. And there's also no recommendation for creating a procedure for paraprofessionals like attorneys can to seek MCLE credit for unapproved activities. We talked with staff and found out that for attorneys that comes up because some attorneys are engaged in highly specialized practices where they might have to, train in medical billing or accounting to do their work. And we don't foresee that for paraprofessionals, and we want paraprofessionals to take only approved courses.
Thank
Other
you.
than that, these are all direct adaptations of rules applicable to attorneys. Sharon?
Thanks. Quick question, and I think this was covered in the memo, but with the first one, with the IOLTA accounts, that would be distributed to legal aid organizations following the formula, the current formula?
Correct.
Thank you.
I move that these be adopted, all
Oh.
6 of them.
We've
we
done
have a
that.
motion.
Oh, we got a motion, you're right.
Yeah.
No further
I was
comments.
just waiting to see if there was more. I mean, I know this is, I know we've seen it and I know it mirrors the rules other than, as Brady indicated, I was just waiting to see if there were more hands for discussion. But not seeing that, Linda, you can go ahead and take a vote.
And so this one was moved by Fleischman. And who was the second?
I was the second, Kim.
Okay. All right. Bashan,
Yes.
Reynoldson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
Yes.
Sarouche, Spyro,
Yes,
Judge Wiley.
Yeah.
The motion carries.
All right. And I believe, Leah, am I missing something? I think that is what we can accomplish today, thanks to people staying a little bit later. I know
Are we
there
going
was
to
Yeah,
review the attorney-client privilege one that got
Yeah,
taken?
my issue's real simple on
Okay.
privilege.
So let's put that up.
Brady, my issue is the scope of the privilege has to be limited to services a paraprofessional, to communications a paraprofessional provides within the scope of their services. So if a paraprofessional is advising a client as to immigration, A, they shouldn't be doing that. B, if you have the privilege cover that, then you're going to have to deal with the crime fraud exception because the paraprofessional is engaged in the unauthorized practice of law.
So what about, so this is the one area where there might not even need to be a statutory change because the privilege is defined as applying to confidential communications between a lawyer and a client, with a lawyer defined as anyone authorized to practice law or reasonably believed to practice law. So the regulation subcommittee thought that we should nonetheless be explicit. Now, I'm wondering if here your concern might be addressed by adding a provision that, with the exception that the privilege shall not apply where the paraprofessional is acting outside the scope of the license and the client knows or reasonably should know that they are acting outside the scope of the license. Because again, the privilege doesn't ask, you could not be a lawyer at all, but if the client thinks you reasonably, then they're entitled to the privilege because it's the client's privilege.
I'm not sure about that last part.
Oh, yeah.
Ira? Oh, no, Stephen, whenever you're done, Ira.
Yeah,
Let me
I
think
was
about
about to agree with Stephen. Then I realized, yeah, that it's the client's privilege, so that makes me, and also there's cases that say that it doesn't apply to just any communication between a lawyer and a client. It's got to be communication within the scope of what the lawyer is doing for the client. And so maybe we don't need a change.
We arguably don't. The Evidence Code 950 says it's used in this article, lawyer means a person authorized or reasonably believed by the client to be authorized to practice law in any state or nation. The thought was, since we're creating a new license category, that we would be specific. But this could be one where we just flag it for the legislature and say our understanding is this would apply, but you might want to.
Yeah, I'm worried about paraprofessionals holding themselves out beyond the scope of their license, and the paraprofessional knows that, but the client doesn't.
Well, the
Right,
reverse
so
is true. Like Brady said, the reverse is true too. You believe that your paraprofessional can help you in an unbundled service. It can be case A, and then you haven't retained them and they haven't retained you in case B. So is that something that either the paraprofessional or the client's really going to understand? Case B, trademark B, lien grant deed B is not included. So this is a sticky wicket, and I don't know that just calling a paraprofessional a lawyer under 950 is really the way to go either.
Amos?
Yeah, so I think it's really important to understand that when clients go to legal professionals, they often can't parse out which facts and which laws are relevant to one issue versus another. And the point of the privilege is to encourage clients to be forthright and honest and divulge any information that may be relevant. And I think it would be a very poor policy decision if we limited the privilege in such a way that clients could not be open and honest, or would have to first confirm if the facts or theories or information, technically falls under the license or not. I think we resolve that issue in the rules of professional conduct by requiring paraprofessionals to not provide legal advice beyond the license and to refer it out if it's beyond the license, but to make that not privileged information, and then would have to be revealed, on a subpoena or discovery. I think that would be a big mistake.
So Steve, what's your problem with this? Again,
Because there are communications between paraprofessionals and their clients that would relate to legal matters that the paraprofessional has no business communicating with them about.
Can I speak to that?
Please, Julia.
I mean, the fact of the matter is that I agree with Amos that they don't know when they come in how exactly every fact applies to what kind of case. Maybe even the paraprofessional doesn't know if it's really going to be something that they can handle or not. But there's also a policy behind communications with an attorney where we maintain confidences. So it may not be subject to the evidentiary objection of attorney-client privilege, But there is in the Business and Professions Code, a requirement even for paralegals to maintain the confidences and confidentiality of our clients, even if that is a broader scope of communication than the actual privileges. So, I mean, the privilege we have to make sure we remember is something that's going to be asserted as an objection to production, against objection to testimony or something like that. But it does not mean that we all are going to be talking about our confidential information that may be embarrassing or entrusted to us as attorneys, even though it doesn't fall under the privilege. So, I mean, I just don't think we can expect that everybody's going to do this perfectly at this point, and that because even as a lawyer, even if I come to learn things about my client, I still, unless I am being subpoenaed by a particular authority, I'm not supposed to be talking about them because I'm supposed to maintain their confidences to speak to me. So I just think that policy should prevail.
I propose a compromise. Instead of reaching the merits of this issue, what if we just passed a resolution? We recommend that the legislature adopt provisions determining the extent to which the attorney-client privilege applies to communications between paraprofessionals and their clients, and let the legislature sort it out.
And paraprofessionals and refer attorneys to whom they refer things.
Sure.
Brady?
I'm fine with that if that's a motion that wants to be made, that someone wants to make and can be voted on. I was just going to point out I'm having a hard time seeing why a change is needed, and I'm putting myself back in a regulation subcommittee meeting. Part of what we want to encourage is the clients to make as full disclosures as possible, even if their problems go beyond what a paraprofessional can do. They should tell the paraprofessional that, so that the paraprofessional can make referrals. And if the paraprofessional commits unauthorized practice of law, that shouldn't take away from the client's right to have had confidence in his communications. So I think either approach is workable. What's on the screen, or just making a recommendation.
Right.
Legislation.
Yeah, and I think that's the issue, which is what Brady's identified, which is certainly the sentiment from the committee that put this forward. I don't want to speak for them, but just saying that they're to consider this doesn't give any of the input that we have. So I mean, I don't know.
Maybe we can see if there is a motion in a second for what's on the screen, because maybe it's not going to be a unanimous vote, but we could see where we are.
I move that we adopt what's on the screen.
That was Ira.
I second
Yeah,
that.
that's Ira, sorry, yeah, because
And Dana, were you the second?
I am.
Thanks very much. So Linda, it was moved, what is on the screen was moved by Ira with Dana as a second, and we can see where we are.
Okay.
Super quick friendly amendment that it should relate somewhere to the communications between the paraprofessional to the attorney.
I don't think that's necessary. It's the scope of the communication and how it covers paralegals and continued communications and agents. That's all in the law already. So I don't think that's necessary.
Okay. I'll take you at your word, Brady.
Okay, ready to take a vote?
Yes.
Yes.
I'm not sure who's still here, so I'm going to call almost everybody's name. Bashan,
Yes.
Brynelson,
Yes.
Falma,
Yes.
Fleischman,
No.
Hartson,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
I think he may have just left a second ago.
okay, Shining.
Yes.
So Roosh, I think for Reba had to leave. Spyro,
yes.
Judge Wiley,
Yes.
the motion carries.
Okay. So I think that's it for that. And it's 4:31. And so I think I better say goodbye to everyone before someone else remembers something that we're supposed to vote on right now.
See you all in 10 days for our very last meeting.
I know.
Well, no, our second to last meeting.
This is our second to last.
No, because we're gonna have to come back and review the public comment and make
Oh, right.
potential revisions in December.
Okay. Did you see my face?
Yeah, all of a sudden I thought there was a second one between now and, when we have to present to the board. So anyway, and I'm sure I'll reiterate this in December, but I feel like I've gotten to know all of you so well that I really do hope that at some point I can actually be in the same physical space with you and have a, conversation just like two human beings who've actually gotten to know each other through the course of working on this together. So anyway, I don't want to keep you any longer. Have a lovely evening and I will see you soon.
Can I
Just
ask a
a
question?
real quick question.
Yes. Yes.
Will the gift baskets be delivered for the second to last meeting or the last
Yes.
meeting?
Depends how you
I'm just
behave,
asking.
Judge Wiley.
I'm just asking for a friend.
I just want to know, so our next meeting is September 10th, correct?
Correct.
That's correct.
Have we selected the final meeting?
No.
No,
Okay.
it's way out in December, so no. I mean, I guess we could, but no, we have not
Thank
at this
you.
point. Thanks, everybody.
Bye-bye.
Bye.
Bye.